Are you academically fit? Chances are there's a bit more working out that you're going to have to do. Hi, and welcome to The Law Simplified. I'm Shaveen Bandaranaike. There is a fundamental requirement of any law student, as well as those who progress on to a legal career or a profession in law, to not just understand the law itself, but also formulate an argument that sets them apart from the rest. The difference between successful and unsuccessful lawyers or barristers or solicitors or attorneys at law is how best they gauge a situation and appropriately address that issue in the most innovative manner possible. From a university or institution standpoint, from your qualification itself, how these institutions, universities, as well as lecturers, professors, tend to train you to get to that point is through assessments. Giving you fact pattern scenarios, philosophical or theoretical questions in the form of essays. All of this is meant to hone your techniques and skills in not just understanding what the law is, but to formulate your own legal personality. On a number of different occasions on this very YouTube channel, I've tried to impress upon you how best to develop your own voice, so to speak, and build your academic prowess. Oftentimes, however, when I've spoken to my fast track and masterclass students, I've understood the notion that many students across many different platforms and jurisdictions don't have a fundamental or picturesque idea of how exactly they need to look at and think about the responses that they provide an examiner. So, this video is meant to look at a sample question and answer, and irrespective of the substance itself or the arguments itself, looking at it purely from a visual standpoint, from a structural perspective, how exactly you're supposed to build your argument. Much like one would try to get fit by virtue of going to a gym or playing a sport or keeping athletic, so to speak, the same is true about an examination or studying law. Let's have a look at how you need to think about your responses in relation to a question presented to you. For this illustration, we are not going to focus on the question itself, its respective breakdown, or for that matter, the substantive articulation. What we are more concerned about is looking at the visual appeal the question or the response rather presents. Oftentimes, many examiners are fatigued when they look at scenarios or fact pattern questions or essays being articulated in a relatively haphazard manner. So there are a few hallmarks, few traits that you can hone in, so to speak, to your responses to make it look fit. In other words, when an examiner does read it, it looks like a healthy response. From a structural perspective, from a visual perspective, using certain tropes in order to indicate to the examiner that you are someone who has looked through this with a fine-tooth comb and you are an academic professional. Now, this question in particular relates to trust law, and I generally recommend whenever you get a question to formulate your structure at the very outset. By this, what I mean is to create signposts and then break down the areas that you're going to talk about and explain to yourself essentially what you're going to tackle as you move forward. This is purely there for cosmetic purposes in this context, just to show you an idea of how a breakdown would look like. You're more than welcome to pause this video at this stage, have a look at the structure that I've created, and we'll straight off go into the actual articulated response. Remember, we're not focusing on the substance, we're going to look at what makes a response look good. Okay, so in relation to this response, there are a number of pertinent aspects that I want you to focus on. Firstly, notice how each aspect is signposted. What I mean by signposting is to indicate to an examiner the overarching theme or what is being considered in the paragraphs succeeding it. So once an examiner looks at this immediately, even before going into the substance in particular, he or she would know that the first part of this is the introduction. The student is going to go on to talk about Milroy and Lord, then on to the different exceptions, starting with Ray Rose and looking at the trajectory and the chronological pathway of precedent case law all the way up to unconscionability in Pennington and Wayne. Signposting is very important to give your examiner a teaser as to what you're going to talk about, and more often than not, examiners will essentially pass you by just looking at whether you've spoken about the right aspects. So it's very important that you have them and you note them down properly. Notice then the manner in which, and this might seem quite pedantic at first, but notice how the formatting of this document is uniform. By this, what I mean is in terms of font or the typography, the fact that it's justified, it's evenly spaced, and throughout the response, you will notice this pattern emerging. Now, it doesn't have to be in this particular typography or font, but it pays to have consistency throughout your work. Always remember, depending on the requirement of your jurisdiction and university, to use footnotes and citations. This shows on the one hand that you have done your homework, and from an academic standpoint, it does show that you're thorough with your work as well. Apart from this, maintaining the consistency, make sure in terms of case law that you take time to utilize the style required to differentiate cases and other authorities from the rest of your response. Oftentimes, for my own fast track and masterclass students, I've gone through countless feedback reports. I've gone through responses provided by students falling short of this, and it leaves a bitter taste in an examiner, particularly because it shows that the student has lacked a care for detail. Finally, once all is said and done, you must try and conclude what you have set out in the precedent response. Now, more often than not, there might be some examiners or professors who would not want you to conclude, or would not want you to have a specific area as a conclusion. And oftentimes, I'm one such examiner or one such lecturer who prefers there not to be a conclusion. But you need to cut the cloak according to the cloth, so to speak. So make sure you have a look at the question, whether it indicates a particular response is needed from the student, from you. And if that's the case, if it's asking you to critique or analyze, it's always good to have a conclusion. It's always good to have some sort of closure to your response. Right. This video was meant to be a quick outline of not the substance nor the arguments for that matter, but purely on a visual perspective, how you need to think of your responses as a whole. From the introduction being considered as your head and your thinking, to the body being the figurative and the literal body that you're working out, to the conclusion and your analysis being that which gets you from point A to point B, your feet essentially. Looking at your body and considering it or paralleling it to that of a workout, the days that you allocate to cardio, the days that you'd allocate to your upper body, your lower body, and leg day, of course. Thinking of it in that perspective and applying it to your examinations makes it far easier to have a well-rounded response presented to your examiner. If you'd like to learn more about how to break down questions and articulate responses with much like in an examination or an assessment submission standpoint, I highly recommend having a look at the online law school platform, complete not only with theory lessons but also tutorials and workshops which will guide you not just in relation to passing your examination but acing it altogether. But that being said, until the next time that we meet, have fun, stay safe, and as always, obey the law.